Well, hello there, everybody. Hope you are having a good Sunday. And I'm sitting here, obviously, with my friend, my heating pad, since, the chronic pain and all that fun stuff. And today I do have a very special guest with me. I have Doug Brooks, who is an attorney, and he has been, I guess, practicing law well over 30 years and has been involved in other cases involving multi-level marketing companies. So I'm going to go ahead and bring Doug on. And what I did is previously I had put up a post in my community tab. And also I think on one of my live streams, I had given instructions that if you have a question for him, go ahead and drop it down there. And so that's what we're doing. It's basically a live Q&A. It's just that we already got the questions in advance. And so Doug is going to be going over the questions and the answers, or I'll read the questions and he can answer them. We'll just kind of figure that out once we get started. So without further ado, let me go ahead and bring on Doug.
Well, hey, Yolanda.
Hey there, Doug. How are you doing?
Very good, thanks.
Yay.
You made me younger than I am. I've actually been practicing law for over 40 years.
Oh, okay. Well, I was close, just,
I'm trying to figure out how to... Here we go. All right.
And hopefully my towel will not fall down, because if it does, the sun will be there and then everything will look really funky on my end. But I did want to at least, be here with you.
All right. It's great to see you and hear your voice.
Same with you. And I know I sent you the questions. Do you want me to read the questions, or do you want to, read the questions yourself? How would you like to do this?
I've got them in front of me, and I've done a little bit of preparation, so I'll just go ahead and read them. But feel free to interject or ask additional things, whatever you want to do.
Okay. Well, I'm going to pop off because I want to give you center stage, since you're going to be, answering things, and I'll pop on if I have a question. Does that sound good?
Absolutely.
Okay. Yeah. All right. So everybody, here is Doug, and let's give him a warm welcome. And I do want to say thank you, everybody who is in the chat. I really appreciate it. Hello there, Joe. So glad you're here. Sweet Goth. Always good to see you. And I'm so sorry, I'm not going to probably pronounce your name right. Yesin, and I'm sorry if I mispronounce anyone's name. I'm terrible with names. And hello, Angel. Nice to see you as well. And Medina, I think it's Medina. Sherry, good to see you. Thank you for being here. And then there is MD Kashim. And again, I probably did not say it correctly. And Ball, it starts with a B. That's about as good as I'm going to get with that. So I apologize in advance for not being able to pronounce names. Anyway, Doug, take it away.
Sure. Well, good afternoon, everyone. Thanks to Alanda for having me on. And like I said, I'm going to go through these questions, and then if you have more questions, I'm sure Alanda will figure out a way to get them to me. The first on my list is someone asked, now that there is more time before the trial, is it possible for additional charges to be filed by the SEC or other agencies? If so, what might the charges be? Yes, there is more time. And it is certainly possible for the SEC to amend its complaint. They've done it once before. Although the reason for the prior amendment was simply to respond to arguments that Onpassive and Ash Mufarah had made. But they could, if stuff comes up in discovery, for instance, they could, that give rise to additional claims, they could add those. There's also the potential for a criminal action by the Department of Justice, which is a separate agency. If the SEC thinks that there is sufficient evidence, they could refer some claims to the Department of Justice. Theoretically, the FTC could step in, but I doubt that. I think those agencies avoid stepping on each other's toes when they're prosecuting a pyramid scheme. So I think yes, as to what those other claims might be, I have no idea.
Okay, that's what I was going to ask.
Yeah. If the next question is if the SEC wins the case, how are the funds collected and what happens to the funds? Do they go back to the victims and the founders? That can be dicey. If they win the case after a trial, then the next step would be to find out where the funds are. And actually, I'm sure they're already looking into that. But they would have to find the bank accounts or other accounts that the defendants own. And that can get very difficult because, we're dealing with an international group of defendants here. So the money could be in many different countries. And there are some countries that make it somewhat difficult to trace funds. But the SEC has a lot of experience with that sort of thing, and I am sure they already have been working on it. And there is at least a potential to recover some funds. As to what happens to those funds, partially it depends upon whether the SEC assesses a penalty, a civil penalty. This is a civil action, not a criminal action. Or gets an order of disgorgement. If it's a civil penalty, that money generally goes back to the government. If it's disgorgement, that money can be distributed to the victims. And I should say with the civil penalties, that money can be distributed to the victims, but there's some additional procedural steps that have to be taken. But if there is a substantial amount of money that's recovered by the SEC, there is a potential that could be distributed among the victims. Sometimes a special master is appointed to oversee that and to collect the funds and then to distribute them. It depends a lot on how much is recovered. And it's very rare that people will get back 100 cents on the dollar. Unfortunately, there's been enough time that has gone by that the defendants have probably figured out a way of either hiding the funds or they've already spent them and they're just not going to be there. But I suspect there's going to be some money available for victims.
Doug, will you explain to the audience what disgorgement is, please?
Disgorgement is the concept that a wrongdoer should not be allowed to hold on to the profits of their wrongdoing. So in this case, I mean, essentially, if the SEC proves its case at trial, that means essentially all of the money that Onpassive has collected would be subject to disgorgement. Because it doesn't seem to be any legitimate business going on here. It's all money that has been, again, based on the allegations of the complaint, all money that has been used in this sort of illegitimate enterprise.
There's a question, and Sherry asks, so I can even pop it up on the screen. Imagine that. Has forensic accounting already been done, or is that something that will come during a civil or criminal trial?
Yeah, we don't know, but I think it's a pretty good guess that it has gone on, and it has been going on probably for as long as the SEC has been investigating this case. But there's no indication the official court records that that's happened. I'm guessing, but I have a pretty high degree of confidence that I'm correct on that point. The next question is, what happens if Ash should flee the country to avoid prosecution? Again, this is a civil case, so there's no potential for Ash or any of the other individuals involved to face a prison sentence. So their physical whereabouts don't matter that much. This is the potential results in this case are either an order that, for instance, Ash can no longer be involved in an MLM program, or that he cease operating Onpassive or something like that, or an award of money penalties or disgorgement, as I discussed earlier, or both. Very commonly, cases like this will result in both an injunction, which is a court order that a person refrain from acting in a certain way or participating in a certain type of business, plus some kind of money award, either civil penalty or disgorgement or both. And Ash's physical presence in the country doesn't really enter into it. If it were a criminal action, then yeah, there may very well be a problem there. But we have no indication that there's going to be any kind of criminal action arising out of this case.
And Angel did have a question.
Okay, yeah, why is he so scared? There's a lot of there's a potential risk here. I mean, I think he has spent a lot of the money that, as I understand it, based on the complaint again, that he's collected. So if the SEC says you have to give everything back, he's not going to be able to do that unless he had a lot of assets before before starting this company. So I mean, there's a potential here for a financially a ruinous judgment against him. It is certainly no one wants to be sued by the SEC. It's a very serious matter. The SEC has a lot of power under the statutes that created it, and if he is scared, there's ample reason to be so scared, regardless of whether this is a civil or a criminal case. The fourth question I have is why did Ash's attorneys use the same reason to dismiss the case for the amended claim as they did for the original claim? What is the point of doing that? Is that typical? Yeah, it is. It is typical. They've raised, in addition to denying most of the SEC's allegations, they have raised a number of what are called affirmative defenses, some of which have already been disposed of or denied or dismissed by the judge in her August ruling. But they may. It's very common for a defendant to assert the same defenses because they want to preserve their right to appeal later on. I mean, they may, once the case, they can't appeal until there's been a final judgment, and that won't happen until after there's either until there's a trial. So those defenses that the judge has already dismissed, they could, once the case is concluded at the district court level, if Ash and Onpassive decide to appeal, they may raise all those issues again to the appeals court. But it's sort of a procedural thing. It's their way of preserving their right to appeal those defenses.
And Doug, do you know what those things are that the judge already has denied?
Yeah. So the Onpassive, the defendants filed a notice of withdrawal of certain affirmative defenses about a month ago, and what that refers to are essentially the defenses that the judge ruled on in August, and those are things they are basically procedural defenses. Failure to state a claim for relief. There's a rule, a federal rule of civil procedure 9B that says if you claim fraud, you have to claim it with particularity. The judge ruled that the SEC had particularized the claims of fraud, but the judge, said, that dismissed that defense, but they have continued to raise that. Basically, all of these are variations on these procedural issues of whether the SEC's complaint, standing by itself, is sufficient under the rules of civil procedure. It's kind of technical, and in the grand scheme of things, it doesn't mean that much. But essentially, as I said before, these are Onpassive's efforts to preserve these issues for appeal if they ever do it. I don't think any of these is a particularly strong argument. I think the bigger issues are the real underlying nature of this company, whether it's a pyramid scheme or not, and whether the investors were misled. And I think the complaint is, the SEC did a really thorough, detailed job of going through what Onpassive did and explaining why it was fraudulent and why it violated the securities laws and why these founder positions are, in essence, securities, like under the definition of the federal securities laws. These are investments, and if you are selling investments in a company, you have to register with the SEC and provide a prospectus, a series of disclosures to investors. And Onpassive and the defendants did none of that. I think the case is laid out very, very clearly. It's a strong case, but the defendants are entitled to have a jury decide whether or not they're liable for this. So that's what's going on now. Next question is, the OEES has been down since June 28th, 2024. Will this have any bearing on the case? And actually, Alana, can you help me on that? What is the OEES?
It's basically their back office.
Okay.
It's the Onpassive ecosystem.
Yeah, it wouldn't have any bearing on the liability issue. It is more an indication of the status of Onpassive, and I suspect if their back office is down, And my understanding is that's if you are being recruited, you go into that back office. So I think it's an indication that things are not going well for the company, but it doesn't really affect the legal issues that are raised in the complaint.
Yeah, their rationale for it being down for as long as it had been down was that they were migrating the database over to a different database, which it doesn't take months on end in order to do that. But that's basically what they had sold to the founders of, like, oh, it's just taking longer, which, I mean, it doesn't pass the sniff test for anybody who knows anything about how that is.
Yeah, I mean, I don't know if this is analogous. My tech skills are extremely limited, but I do have a website, and I recently had to change website hosting, and the whole process took about 30 seconds. So if we're talking about weeks or months, I think that's an indication of something bad happening. Since there is now a new schedule and the trial date was moved to April 2026, can we presume that mediation has not gone well? Yeah, I think that's a fair estimation. Obviously, we don't know, and the reports that the parties have filed with the court that we can see are pretty bare bones. I mean, they don't say much. So, we can only guess, but the fact that they've had a couple of sessions and it's been months and we haven't seen any indication of a settlement, yeah, I think we can presume that that it's not going well. But I could be wrong. It could be that they're arguing over some details, that they have an agreement and they're just working out things like, how much money the defendants are going to have to come up with, or things of that nature. But we just don't know, and I don't have any information as to how that's going. It is suspected that Ash is running out of money. If that were to happen, would he then get a court-appointed attorney? And if he did, how would the attorney be brought up to speed in the case? Again, this is a civil case, and there's no right to defense counsel in a civil action. In a criminal case in the United States, the Supreme Court has said that the defendant is entitled to defense counsel, and if they can't afford it, the government has to provide them with counsel. But that's not true in a civil case. But of course, another difficulty is that a corporation like Onpassive can only appear in a case through a counsel, through an attorney. So there would be a problem if the defendants are unable to pay for a lawyer. That could definitely result in more delays here. But I mean, ultimately, the case would go forward whether or not the defendants have a lawyer. I have another set of questions that Alonda sent me. Okay, now that the trial date is set for April 6, 2026, what is the likelihood this case will go to trial? It is not uncommon for trial dates to get postponed for various reasons, and they can range from problems with discovery, or simply the judge's own schedule. The judge, every federal judge has hundreds of cases, and they're constantly juggling their trial schedules. So delays can happen. But the other thing is most civil cases do get settled. So it is certainly possible that between now and we've got a year and a half, a lot can happen then. And I think there's a pretty good chance that at some point the defendants are going to throw in the towel and say, okay, how much are we going to have to pay to get out from under this? But we just don't know. I mean, as with the settlement discussions, we just don't know how things are going. So it could happen. And at this point, it's simply guesswork. How does the new schedule impact discovery? Will they be able to bring anything into evidence from 2024 and beyond? I think, first of all, the new schedule is based, and this is based on the motion that the parties jointly filed to extend the discovery, the whole trial period. That primarily had to do with discovery issues, including the fact that this is an international case. There are a number of witnesses in other countries, primarily India, and there's some indication that there are delays that the SEC is facing in terms of getting both some kind of an agreement as to what witnesses will be deposed, and then the SEC can't just go into India and start taking depositions. They have to go through some legal procedures in India to get the equivalent of a subpoena issued in order to require the witness to attend and testify. So that evidently that process is taking a long time, and I am not familiar with the legal system in India. What little I know is that there are a lot of delays, and it is slow moving. So unfortunately, because we have witnesses there and elsewhere across the world, the discovery is going to take longer in this case than it would, for instance, if the company were entirely based in the U.S. And yes, if relevant or material things happen after 2024, that could certainly get into evidence. Just really depends on what happens. But if the defendants do things that implicates them or reflects on what happened here, that could definitely come into evidence when the case is finally tried. Okay, I see a question from Sherry F. Does the SEC have its own judges, or are they from the federal court system? This case is in the federal court system. And this is so this is a judge that handles all sorts of cases, criminal and civil, and cases with private parties and cases with government agencies. So this is not just an SEC administrative action. This is a federal court action, and it will proceed according to the federal rules of civil procedure. On September 30th, 2024, there was a publication entitled Defendant's Notice of Withdrawal of Certain Affirmative Defenses. Okay, I covered that with Alonda a few minutes ago. And essentially those, as I said then, it's we're talking about some procedural defenses that the trial judge has ruled against the defendants on, but they could still be raised on appeal later on. The next question is, Ash has painted a picture that this case is no big thing to the founders. They seem to believe he will not be held accountable because he has not done anything wrong. What, if anything, might change their minds? You're talking about getting into the head of Ash or other folks at Onpassive, and just because he says that this is not a big thing, that doesn't mean that that's what he really believes. I think the fact that the SEC filed the case to begin with is in fact a big thing, and they know it. So I think that's just sort of propaganda. I wouldn't put a lot of stock into that. Why are the Onpassive promoters, such as prominent ones like Marty and Chris, not being charged and prosecuted? That has to do with sort of the judgment that folks at the SEC who are responsible for this case have to make. And a lot of things can go into that. And for instance, proving a pyramid scheme case is, as I know from my cases, it's a difficult proposition. It's complicated. It's tough to explain to a judge, let alone to a jury. And so you want to try to keep the case as simple as possible. So, one reason to not charge a bunch of other people who may be implicated in this thing is just to try to keep things as simple as possible. Another thing is the amount of evidence that they have. They may feel that they want to be sure and get a verdict against the defendants. They don't want to risk sort of if there's some marginal cases, they don't want to take the risk of not winning on some of their claims. It may be that they plan to go ahead and with the primary case against Onpassive and Ash, and then if they prevail on that, then they'll start going after other actors. One thing that's possible, I've seen this in a number of SEC cases, is that the case goes forward against the primary company that is running the thing, and then once there's a judgment, they may start going after the people who made money at the pyramid scheme. If the company is ruled to be a pyramid scheme, there are winners and there are losers. There are maybe 1% of people are winners and 99% are losers. I have seen a number of cases where the SEC has requested that the judge appoint a special master, and that special master, as a court official, has brought actions against the net winners, the people that 1%, and tried to recover money from them that ultimately would be distributed to the 99%. So that that could happen at a later stage here, and unfortunately, this is all going to take a long time because as we're talking about, this trial date is until April of 2026. So the kind of thing that I'm talking about wouldn't happen until after that. Alonda, did you have another question?
Yes. I'm just kind of wondering if any of these promoters have been paid, under the table by Ash. Would they be looking to collect that money too, to then be able to redistribute it to the founders?
Yeah, absolutely. They would bring those people in and put them under oath and find out, what they got, whether it was, official commission income that they made, or under the table payments, whatever, whatever the source of income from Onpassive, they would be asked about that, and there would be presumably the SEC would have documents and other evidence of whatever payments went out to different people. So that was, we're talking about forensic accounting. We're talking about a long process but there's a saying, the wheels of justice grind slow but exceeding fine, and that's what we're talking about here. And ultimately, people will have to pay up what they took out of this, but it is a long process.
As a follow-up to that, I mean, and I don't know the answer to this, but I would not be surprised if anybody who did get commissions or were paid under the table, if they were, that the income was not reported to the IRS. So would this be something that also they would coordinate with the IRS for them to be able to look at who would receive money to see, has this been actually reported the way that it should have been reported?
Yeah, that's definitely something the SEC could do. If they find evidence of that, they could refer to the IRS, and the IRS could step in, and that's a totally separate agency and a separate set of procedures, but that definitely could happen.
And so the people like getting monthly payments, to say glorious things about Onpassive, they then could be held liable for that. Yeah. They did not. Okay. That's what I was trying to get out. Thank you.
Yeah.
Oh yeah. And Sherry just said like the super chat payments, which are things that you get here in YouTube where people can send in, money as you're doing a live stream, or you can send in a thanks. It's basically money that you receive. And there's also channel memberships, which there's one of the prominent, figures in Onpassive has had a channel membership. And so people have paid to be part of his membership. But, what they've received from it is, I guess just getting more of the same of what he's always said publicly anyway. And I don't really see, it doing much of anything other than lining his pockets. And probably those people could actually use the money.
Yeah. I mean, if they're smart, they are paying taxes on it. I mean, it's income, and they should be, they're just creating problems for themselves if they're not paying taxes on it. But that's the way they got Al Capone.
Right.
But we just don't know at this point.
And there was also someone who was collecting funds here in the U.S. to then distribute them to somebody who allegedly, I guess it was a charity in Africa, to build a school, which that sounds like all kinds of strange. And I don't think it was done technically in the way that it would be done correctly. I mean, that's basically the best way I can put it.
Unfortunately, I mean, the kind of things that you're talking about, they do require a lot of time and energy and effort to follow up. And agencies like the SEC or even the IRS, they have a tremendous number of things they have to do, and it may just not be feasible for them to follow down every rat hole that we're talking about. I mean, I certainly hope that they do, but it's difficult. But that kind of thing of setting up a fake charity, if that's what happened, they are equipped to do that. It's just a question of the willingness to devote resources and in the face of all the other things that they've got on their plate. Let's see, the next question are, how much could we expect the words and actions of the founders to be taken into consideration during the trial? And Alonda, when the founders, as I understand it, are the investors here. So we're talking about essentially the victims.
Right. That's the point.
Yeah, I would expect that at trial the SEC would bring on a few founders to testify as victims as to what they relied on in getting into this. It's sort of it's a decision that the trial lawyers will make in terms of how many people to bring on and what who to bring on and how much how much is that going to impact things. But I'd suspect that there'll be some testimony by victims here. Would the culpability rest solely on the Mufaras? Well, the Onpassive, the corporation, is also a defendant in the case. And really, I suppose it depends on where the money ends up, and if it all ended up with Mufara, then he's going to face the consequences of that. But note that in the complaint, one of the there's Ash Mufara's wife is named as a relief defendant, and what that means, that's a term that's primarily used in SEC actions. A relief defendant is someone who isn't culpable in the sense that they were not running the scheme, but they were the recipient of funds that were wrongfully taken from victims. And so what the SEC has alleged is that Ash's wife, while she may not have been actively involved in the company, she has received money that was wrongfully collected. So there may be one of the things that the SEC may learn in discovery is that there are other people who received money from Ash as a result of this. They may be added to the complaint, so there may be additional relief defendants, or there may be additional actions to try to against those folks to try to recover that money. So I hope that answers that question. Can we expect transcripts to be available for us to review? Yes. Federal court trials are public trials, and in most cases, the transcripts are ultimately going to be available to people can attend the trial or review the transcripts later. There are sometimes there are very limited exceptions if in some cases where a transcript may not be available. Typically, that will happen in discovery if there are issues having to do with sensitive trade secrets or things of that nature. But the trial transcripts ultimately are going to be available, and that's going to be, of course, a while down the road. But the general assumption in the federal system is that trials are held in public. That's part of the way our system is supposed to work. If Ash goes to trial and is found guilty, will he face civil actions, fines, or federal penalties? Well, remember, this is a civil case. So technically the word guilt applies only if there's a criminal case, and that hasn't happened yet. So this is a civil case, and the result could be either an injunction, a court order requiring Ash to either do something or stop doing something, plus some type of money penalty, as we were talking about before, which could either be a fine or a disgorgement. If the SEC does win the case and Ash does not pay the fine, what further steps can be taken against him? Could he be charged criminally for failing to comply with a court order? Yes, if there is a judgment against him and the judge orders him to pay something or provide information about his assets, and he doesn't do that, that could be considered contempt of court, and he could be incarcerated for a period of time based on a finding of contempt. Again, that wouldn't happen until after there is a judgment in the primary case. If funds are recovered, who will receive them? The state or redistributed to founders in the U.S. or worldwide? I think I tried to cover that earlier. Yes, if there's an order to disgorge the ill-gotten gains from the victims, the court could distribute those funds to the victims. If there are civil fines assessed by the SEC, again, there is a procedure where at least some of that money could also be distributed to victims. Is there a time frame in how many times the case can be pushed back? Not really. A lot of that has to do with the discretion of the judge. There are a lot of things going on, and we don't see, we're not seeing what discovery is happening, because a lot of the discovery aren't things that get filed in court unless and until there is a dispute. And as yet, the parties in their motion to continue the case, they mentioned that there had been a few disputes, but then they said they've had meetings to try to resolve those, and so they haven't submitted any of those disputes to the judge. So if and when they do, that will give us some insight into what's going on there. But right now, in the public record, there's no indication of what what's going on with discovery. How will the trial impact the Hyderabad office? Again, maybe I need some help from Alondra on this. I assume the Hyderabad office is something that is owned by Onpassive.
Yeah.
So if there's assets there, then that is a potential place where the SEC could try to collect funds. But again, as I was saying early on here, it's very complicated to try to trace money from country to country, and I'm sure the defendants have had a few years now to try to move their assets around. So it's going to be a process to try to track all that down.
And there's also crypto involved, so I presume that would also add a whole different layer in terms on locating and.
And again, based on my limited understanding, it is in some ways it's easier to trace crypto than other kinds of assets, but it's always difficult. But I am sure that there are folks at the SEC that are following all of this. Will Ash flee the U.S. to avoid prosecution? Well, certainly possible, but again, there's no indication of any criminal action at this point, so he does not face any prison time. He's basically this case will concern his assets and his ability to engage in certain types of businesses. involving collecting investments and that sort of thing. I haven't seen any indication that there is going to be a criminal action, and I don't see any indication that he's trying to flee the country. But that could always change. If Ash cannot afford his lawyer, what is the latest that Ash can wait to request a court-appointed attorney? We already talked about that. Again, this is a civil action. He's not entitled to a court-appointed attorney. If he can't afford a lawyer, he'll have to represent himself. With the judge not dismissing the case, how might it impact the Indian founders? Well, I would assume that authorities in other countries, particularly India, are looking at this. It would not be unusual for communication going on between the SEC and its counterparts in other countries in a case like this. But it's just, we're totally speculating as to whether the authorities in India or any other place will do anything. They may just wait and see what happens with the SEC case and then file their own cases. There may be some kind of coordination going on. We just don't know, and there's nothing in the records in the trial court that indicates anything about that. I think those are all the questions that I had from you, but I'm happy to answer more if you guys have any more.
Yeah, Mark did have this question, and it's basically about the process to be able to call witnesses from foreign countries, like particularly the employees.
Yeah, and Mark, I'm sorry, I don't know what the process would be in India. Each country is different. The best I can say is that it's going to be a lengthy process. I just don't know how the Indian legal system works in terms of the procedures that have to be undertaken based on the filings in the U.S. case by the SEC and the defendants. This is an issue that they're working on because they mentioned it in their motion to continue the case. So we know that they are aware that there are witnesses, they want to have testify, and I am sure that the SEC are consulting with their counterparts in India and people who are familiar with the Indian legal system, and they're working on that. But I can't be more specific than that.
Okay, well, thank you, Doug. I just want to say thank you for your willingness, to be here and answer the questions that people had, because I think it's, very interesting to be able to get your perspective, because you have knowledge and stuff that, I don't have knowledge in, because obviously this is your area of expertise. And it's, just good for us to be able to hear from an expert such as yourself.
Well, thanks, Alana. I'm happy to do that. And if other things come up, you know how to reach me, and I'm happy to talk some more.
Yeah, I sure do. Well, I'm going to go ahead and close things out. And if you can hang on for a minute, and I'll talk to you after we, finish everything. All right, everyone, that's what I had for you guys today. I hope you did enjoy hearing from Doug. He always brings such a great, informative information to us for us to even, think more about what's going on and maybe what's not going on. But I do want to say thank you to everybody who participated in the chat. Also, thank you to any of the lurkers. Thanks to all of you who are subscribers. I really appreciate your support so very much. And I hope you have a great rest of your day. And don't forget, you're beautiful and I love you. Until next time, I'll talk to you later. Bye now.